Hello, everyone. We'll be starting in about 3 minutes to allow people to log in.
Good evening, everyone. We are so delighted for everyone to join us this evening. We are looking forward to and very excited by the discussion that we're going to have this evening on what we are calling Following Suit, how law firms and nonprofit organizations litigate together for social change. First, in terms of a few housekeeping items before we begin, Please note that your video and your audio are not on and will remain off during this broadcast. That is, you will see us and hear us, but we won't hear you. We'll be having this discussion for probably about 45 minutes or so, and then we'll open the floor to questions. But I would also encourage you to submit questions in the Q&A box as we go along. Certainly to the extent we can incorporate these questions, we will try to do so and keep the conversation flowing. For those of you that are joining using your cell phones, this function may not be available. So let me introduce myself. My name is John Yang. I am the President and Executive Director of Asian Americans Advancing Justice, AAJC. Advancing Justice, AAJC's mission is to promote and advance the civil and human rights of Asian Americans and to promote a fair and equitable society for all. So what this means in terms of our work falls into a number of different categories. We are part of a collective of 5 independent affiliates under the Asian American Advancing Justice brand, affiliates that are located in Los Angeles, San Francisco, Atlanta, and Chicago, as well as us in DC. We also have a community partner network of over 160 organizations in 34 states, as well as the District of Columbia. And we all work together to promote social change, promote social justice. In terms of our organization in DC, we focus on a number of substantive areas for the Asian American community, most particularly and most frequently around immigration, census, voting, discrimination, and tech and telecom. And we do this work oftentimes through 4 different areas, and certainly overlapping areas, in the way of policy advocacy, specifically on Capitol Hill, with respect to litigation, with respect to community engagement, and with respect to the media. So we're focusing on litigation tonight. And we're focusing on litigation because we know, and we've seen in the press, how litigation has played a large role in some of the social justice issues that we see today, and seeing the courts as a bulwark in defending our democracy. And with respect to the litigation, I am proud to say that Advancing Justice AAJC has played a large role in that. That role includes defending against, protecting against the inclusion of the citizenship question on the 2020 census. Through our organization's efforts, as well as several organizations and several law firms' efforts throughout the country, we were able to keep that question off of Census 2020. We have done work around voter purges and voter protection, namely with the Texas voter purge last year, as well as in immigration in terms of defending against and ensuring that a fee waiver rule that would have really decimated the ability of low-income individuals to obtain waivers when applying for citizenship was not implemented. Now, this work does not happen magically. This work happens through obviously dedicated staff, partnerships throughout the country, and that staff and that partnership requires support from all of us. And so certainly part of this webinar, what we are asking people to do is support the work that we do. We have a litigation campaign fundraiser right now ongoing to seek to get to $500,000 over the course of 3 years. We're a little bit over halfway through of the campaign, and we're over halfway through in terms of the money raised. We still need to raise a little bit under $200,000 to reach our goal of $500,000. So we certainly would ask you to support these efforts if what you are hearing tonight resonates with you and the work that we do. The link for donating to us should be appearing in the chat box. So let me introduce the panelists for this evening. First panelist is with Advancing Justice AAJC, and that is Niyati Shah. Niyati is the Director of Litigation at our organization, and she served as one of the lead attorneys in the Lupe versus Ross case. And this was a case that was a successful challenge to the addition of the citizenship question in the 2020 census. Prior to joining Advancing Justice AAJC, Niyati investigated, litigated, and advocated against violations of federal constitutional and election laws nationwide, including the Voting Rights Act. She is an expert on the implementation of Sections 5 and 7 of the National Voter Registration Act, working both cooperatively with, as well as litigating against, states to enforce the NVRA in federal courts across the country. Our second panelist this evening is Debo Adegbile. Davo is a partner and a member of the Government and Regulatory Litigation Group at WilmerHale, where he focuses his practice on a range of matters at the intersection of law, business, and government policy. He also co-chairs the firm's anti-discrimination practice. In addition to his practice at the law firm, Davo has had a career in this field, in the civil rights field, Among other things, he has served as the NAACP Legal Defenses Fund in senior leadership there, including as the acting president and director counsel. He also has had roles in the Senate Judiciary Committee as well as private stints in law firms. So Davo should be joining us now. So our two panelists tonight will really explore this intersection of nonprofit organizations, private law firms, how we litigate together, how we really promote social change together. And to frame this conversation, oftentimes I think when people think about social impact litigation, people might have visions of Thurgood Marshall at the NAACP Legal Defense Fund, or visions of today, what people see in the news with respect to the ACLU. But the reality is actually much more complex than that. Certainly organizations like LDF, ACLU, organizations like ours litigate these cases, but they're oftentimes in partnership with law firms, in partnership with different organizations and different constellations within this ecosystem that we call social justice. So that's our intent, to examine these issues. And like I said, I definitely encourage questions, submit them in the Q&A section of this Zoom webinar, and we'll try to address them as we go along. So let me start with an opening question and just ask, maybe I'll start with Davo and ask him to talk a little bit about sort of civil rights organizations and what the role that they play with respect to impact litigation. One of the things that people often talk about also is thinking about civil rights organizations as private attorney generals. Certainly we see attorney generals litigating in this day and age, but there's still an interesting constellation, interesting ecosystem behind all of this. So Davo, can I ask you to address that?
Sure. Well, first, it's great to be with you and with my friends in the larger AAJC family. I'm happy to be here with all of you. The question you ask is an important one. The role that not-for-profits have played and serving as private attorneys general, as you have suggested, is a vital role. And I think one of the things that many of the civil rights organizations do is that they collect expertise in a range of areas that affect their communities. And so in a sense, over time, the law has become more and more specialized, not just in this area, but generally. There's a greater degree of specialization. And having specialization in the areas of civil rights, understanding the doctrine and the evolution of the law, is something that the civil rights not-for-profits really bring to bear. A level of understanding of the context of the previous cases, of the trend lines in the law. But as you suggested, John, in the modern day, there is a lot of partnering that's going on. In some ways, my career has been marked by weaving in and out of the private sector and the not-for-profit and governmental sectors as well. And I have tried to have a synergy, always having a goal of trying to advance principles of justice wherever I am. And so I've sort of organized my career around the idea that wherever you are, there's something that you can do to contribute to a greater measure of inclusion and equality, regardless of what the name is on your business card or the office building that you're walking into. And having that as an organizing principle has helped me develop a set of relationships over time, and to engage in partnerships in litigation and other contexts, in which I've learned a great deal from folks in civil rights organizations, both when I was working at a law firm as a junior associate, and that continues today, including some of the partnerships that I'm in and developing with your lawyers as recently as this morning.
Great, thank you very much, Davo. Actually, let's use this as a jumping off point with respect to Niyati is, in terms of how you got involved in doing social impact litigation. I know we have a number of lawyers, young lawyers on this webinar, as well as some law students, interns. Tell us a little bit about the arc of your career, what motivated you to get involved, and what keeps you in this field now in these challenging times.
Well, I also wanted to start out by thanking you for this opportunity, and it's so great being on this platform with both you and Davo. And honestly, I think the underlying impetus for this is to have everybody have a voice. And encourage systems in place that allow for that and for their inclusion and their value. And for me, my first love was voting. I think that's mostly how we can ensure representation. And when things get hard, we can enforce change through it. And that's always been the goal. But as law students and others know, that when it comes to this work, the civil rights work, there isn't necessarily a step-by-step career path. So, you know, as Debo mentioned, keep your principles in mind no matter where you go and build towards your goal. And that's what I've done through my course, you know, whether it was through legal services or doing consumer protection work, and keeping, you know, it in perspective, volunteering and gathering experience where I could. And then when opportunities present themselves, you're prepared to take advantage of them. And so it's been great. And then that actually has allowed me to be in this position today where we find so many of our rights and our voices being stifled, and to be in a position to do something about it, however small our efforts might be in the grand scheme of things, is a privilege that I thank every day for being in a position to do that. And we're needed more than ever. So I encourage everybody to stay on this path of civil rights and to contribute in whatever position you are, even if you're at a law firm or in the private sector. There are ways that you can do this big and small.
Great. Thank you. And part of the goal of this conversation is to sort of peek behind the curtains, if you will, into what goes into some of these cases. Because I think, you know, people see the headlines about so-and-so filing suit to stop such and such, you know, especially in the current context of some of the initiatives that we've seen, whether it's related to the census, whether it's related to voting. What I'd like to explore with both of you, and maybe let me start with Niyati, is what happens before that lawsuit is filed and the press starts noticing that a lawsuit is filed? What goes into developing that case that starts to generate that whole legal system into action?
Well, for me and for us at AAJC, the first threshold question is, how does it impact our communities, the Asian American communities? Is this something that's going to matter to us directly, and then we'll move forward at that? Or is there somewhere we can be an ally to our fellow communities of color and then the greater civil rights landscape? So that's the first question. And then of course we have our inherent in-house expertise in some core issue areas, whether that's immigration, voting rights, census, or tech and telecom. These are areas that we really do focus on. And then we have in-house expertise on that, and that allows us to know where we need to go and attack or protect, as the case might be, you know, protect our gains that we've achieved through advocacy, or if we've fallen short, to advance them through the courts and through the legal system. And so that's kind of where the initial assessment starts. Then of course you have to develop the facts of the particular case as well, right? And the citizenship question case is a great example of that, where this was going to disproportionately impact immigrant communities. So, and create an undercount, which we were already hard to count communities to begin with. And we had this expertise on the census with Terry Iominnis, who is, you know, the resident guru when it comes to census work. So once we had that, we joined forces with another fellow partner, MALDEF, who again represents communities of color who are hard to count and are underrepresented in the census. And we knew that the census impacts every aspect of our lives, from our voting representation to funding, to how funds get allocated for schools and healthcare and roads and infrastructure. And so we knew that we had to be involved because we needed our communities to be represented and not exacerbate what was already hard enough in terms of counting our communities. And so that's where we got to work, and we needed to know how the census operated. And what were the best practices, and to enforce them through the law. And we did that in almost in a soap opera kind of fashion, as it turned out at the end of the day. But it was really important, and we were able to achieve those goals.
Thank you. I'd be interested, Dabo, for you, now being at a law firm, and we'll talk about your prior work at nonprofits as well, but how do you typically first get involved in one of these cases? Does the firm go out looking for them, or does a client or an organization come to you? It'd be interesting to understand the dynamics there.
I would say most often our friends in the civil rights and public interest community reach out to us with a particular priority that they may need additional resources to litigate and vindicate the principle at issue. And resources here are not just dollars and cents and the financial power of a law firm to help with expert costs and other costs associated with litigation, but to have the lawyers and the additional lawyers to work side by side in what sometimes can be discovery intensive cases that are on very tight litigation turnarounds. Sometimes it's cases in remote parts of the country, and we may be looking for, or an organization may be looking for, a firm that has experience in a particular court or jurisdiction, or sometimes that has litigated a series of cases side by side with you or with another organization in an operative area, so that there's some accumulated knowledge at the firm. And so very often the cases come to us, or the proposals come to us from our friends in the public interest world who are looking for assistance, and know that in our own case at WilmerHale, that we will do what we can in as many cases as we can, understanding that we have to work for our other clients as well, to lend the firm's resources, and that we have a tradition and a commitment to doing so in a range of areas, and that it's an extraordinary experience for our lawyers. Careers are made and blossom from these partnerships, and it very often gives a window into very meaningful litigation that touches people's lives in very tangible ways, that really animates the notion of why so many of our lawyers have come to a firm that likes to practice law in important areas on the front lines of people's lives. And so I would say that the typical path is from the organizations to WilmerHale. However, because we have expertise in a range of areas, because we have appellate practices, and because we watch dockets and see trend lines in courts, sometimes we notice something and we will call the issue to the attention of one of our friends in the public interest community, either to say that there's an important appeal that's working its way through a court that may not be on the radar, but that might benefit from an amicus brief raising the interests of your organization or community, or perhaps there will be a litigable issue that has been identified that for whatever reason is not yet surfaced, or that you have been considering but have been sort of deciding about whether you had the adequate constellation of folks to push into that area in light of all of the many responsibilities that you have with your existing cases, policy work, public education work. You know, I think that's something that folks sometimes miss, is that not-for-profits like AAJC have to wear so many hats, and that when the issues bubble up, not all of which you get to control, you have to answer the bell, whether you have all of the bodies and adequate staffing to do it, right? Because you are an important voice for a vital community that needs representation. You know, there are times when, for the public interest organizations, you just must say yes, right? When the immigrant ban is happening, when people are being stopped at airports, the question isn't, do I have enough staff or do I have enough lawyers? Lawyers from across the country went to go be on the front lines because that's where you needed to be. And I think this happens particularly increasingly in our current circumstance, where day after day, there are issues that are percolating up that were not part of some long-term strategic plan about how to advance interests, but are more in the nature of how do we hold the line against incursions that may have very deleterious impacts on your community. And so I think that the synergies between the private sector and law firms and public interest organizations have never been more important than they are right now.
Thanks. Following up on one particular piece, I'd be interested in understanding a little bit more about sort of how these, whether this is something new, because at least, as you know, I was at a private law firm for quite a while, many years ago. And at least for me, the notion of pro bono service at a law firm focused more on direct services for individual clients from clinics, et cetera. Also focused on amicus briefs, certainly. But this notion of impact litigation and firms being involved seems a little bit new to me. I mean, can you, especially from your time also at the Inc. Fund, am I just incorrect on that, or has this evolved over time?
Well, I think in a sense, there are dimensions of both. I think that there has been a history of law firms participating in some important cases over time in different ways. Sometimes it was more in the background than as co-counsel. It was supporting organizations, working on briefs, perhaps not always appearing on briefs. I think that there was a time, and perhaps we're seeing a bit of a shift in corporate America, where the understanding of people that are coming into companies, of the millennials and the like, is that they want there to be less of a distance between their values and the places they work. I think in a different generation, there was sort of an understanding that you went to work to get your check, to be able to pay your rent or to pay the mortgage, and that you lived your life outside. I think that now what we're seeing a little bit more is that there is a need to feel that somehow your company, your firm is aligned in some high level way with the values that you espouse. Diversity or openness to people from every part of the world or something else. And what that has caused is it's caused companies and law firms alike to be a little bit more forward leaning and less risk averse in pushing into cases that are about these issues, pushing into issues sometimes that are about these things. And so I think that there's a little bit more of a forward lean and less of a sensitivity in terms of how clients might feel about it or what the impact will be. Now, that doesn't go away completely. And of course, you have to be very careful about conflicts. There are ethical rules and there are some boundaries. But I do think that there has been a change over time, which has invited more or interested more firms in getting involved in this type of work. And the other reality is, I think as the industry, including some of the trade magazines like the American Lawyer and the like, actually scores and grades firms, and one of the criteria is the pro bono commitment and how broadly that pro bono commitment is shared and dispersed throughout the lawyers in the firm. And so doing meaningful pro bono work is great for the reputation of the firm. It's great to help your lawyers gain experience with proper supervision in cases that really matter and to grow as lawyers. And I think it most importantly, it helps the team come together to advance the interests of the clients. So I think there are lots of reasons why it has expanded, John, and that there are more firms that are interested in participating in different ways. But I do think that if you trace it back, that there were firms, I think WilmerHale has been in cases for a long time. Yep. There are other firms that have been in big cases for a long time. And some firms that were, consulting with LDF, for example, in the DSEG cases and all of that. So there is a history there. It's not as well documented. And now it's more of a thing that's recognized and marketed in the world. And there are a lot of good things that come from it.
That's appreciated. That's very appreciated to have that arc of history behind how this has worked and how these partnerships have always existed, but have evolved perhaps for the better over time. Niyati, let me turn it over to you to talk sort of the flip question from what I asked Davo, which is, what do you look for when sort of you're figuring out whether to involve a private law firm? If there's a calculation between adding resources by working with another nonprofit versus adding resources from working with a law firm, and then what you look for in a law firm if you decide that partnership is appropriate.
Yeah, so I think a few things. It depends on how litigious we expect a case to get in terms of discovery, how complicated discovery might be, how whether the case will involve extensive use of experts, things like that. So those are definitely resource intensive decisions that we have to make when we're bringing a case. At the end of the day, because we're bringing impact litigation, the burden is on us to prove our case. And as you all know, one of the ways we do that sometimes is through expert testimony, and that is complicated and requires a lot of different aspects and elements to it, including resources involved to do that. So that's certainly one thing. And then, you know, vis-a-vis how to partner, whether to partner with other organizations, is can we do this in-house with our relevant experiences where we have expertise and that we can take it on. And as we did that in several cases, you know, working with these organizations and not having a private law firm. And that adds value in our experience in-house as well going down the line. And so that's an important consideration. Another really big consideration, and this ties into what we're looking for in a pro bono firm, is how culturally sensitive this issue is. Working on behalf of our communities, we need to represent them, how we refer to our communities, how they are treated, in what manner and tone matters. You know, it matters to our communities first and foremost, but it also helps inform courts and judges about what's at stake and what are the changes that are in place and why those sometimes would seem like semantic changes matter. And so when it comes to pro bono counsel, we want to make sure that who's partnering with us understand that. And sometimes these tone choices may seem too political, but they really are important to our communities. And oftentimes, you know, we want to make sure that they're captured, and we don't want to, for lack of a better word, sanitize some of our briefings, because we do want that cultural heft in them, because that's why we are involved in the first place.
Thank you. And then in terms of the allocation, right? And maybe I'll start with you, Niyati, is how do you decide sort of who is going to take the lead on whether it's a particular issue, whether it's a particular briefing or a deposition? Because I at times, you know, I wonder if there are competing considerations, because the firm obviously also wants to give opportunities for their younger associates maybe to do that. Obviously, there's a certain prestige factor involved. So how do you guys work that out?
Well, usually if you're in a partnership, it works out pretty well, and it's in the spirit of collaboration and acknowledging each other's strengths, right? One of the things that I would say is that as a civil rights organization, our subject matter expertise is where our value add is. We have substantive knowledge. We know the through lines of these issues. We know where there might be some areas where we're going to fall into a trap, and we don't want to set it up for other bad decisions down the line as well. And we're very cognizant of that, because we know that we're not operating in a vacuum, that this is, as litigators, we're building on case law here, right? And we don't want to ruin it for all the people that are going to come after us as well. So those are important considerations that we have to make in some of the resource allocations. And so that exchange of expertise is important, but of course, we want to be good partners, and we want to have that collaboration. So we want to ensure that our pro bono partners are getting the most out of this experience as well.
Thank you. And Dave, I'm going to ask you the same question, but actually I'm going to focus a little bit, because this is interesting. With respect to the Harvard affirmative action case, obviously, well, not obviously, but we all know that WilmerHale is very involved in that case as counsel in the case. But it's interesting because the Legal Defense Fund, your former organization, is also very involved as a counsel in the case. So I would be very curious for you to sort of talk us through both the case itself, how the two organizations work together, and maybe from a split point of view, how you view that from both of those different hats that you wore.
Absolutely. So the Harvard case is, as probably many of you know, is one in a long line of cases that have continued to challenge the consideration of race as a factor in college admissions. And one of the novel things about it is that it's one of the first times that the focus has actually been on a private institution instead of a flagship public institution, which is typically how these cases have been filed. And so one consequence of that is that the defendant, Harvard, has hired its own counsel. And I had worked when I was at LDF in the Fisher case, representing the Black Students Union in Fisher, as that case was making its way through the courts and through the appellate courts. And one of my former LDF colleagues argued Fisher in the Fifth Circuit on its way up the first time. And I was there with him in New Orleans for that argument and helping prepare him, Josh Sivan, who argued that case as it was making its way up. And so I left LDF, I came to Wilmer. I thought that some of this was behind me, and then the Harvard case was filed, and it was filed by the same lawyers who had been involved in both in Fisher and also to some extent in the Shelby County voting cases. And so I was right back in a case with some of my recent adversaries, and the role that Wilmer has played representing Harvard in the case has been an important one. But as was the case in Fisher, where the civil rights organizations had an interest in the underlying issue, these cases are brought as test cases. They are intended and filed as Supreme Court vehicles that have as their aim changing the precedent, the existing precedent, and trying to move it in a direction. So they attract attention from the organizations that pay attention to these threats to important decisions and precedents. And for that reason, it attracted the interest of AAJC, the NAACP LDF, and the Lawyers Committee. And each of those organizations, and in particular the California cohort, together with the national organization of AAJC, played vital roles in representing students, current and former students, because Harvard was representing itself as a university. But the issue is about who gains admission and whether or not the admissions process is fair or discriminatory. There are many specific claims, but that's the ultimate issue that's being called into question. And so to be able to have in the case the voices of students, past and present, explaining the context in which they applied and what their views were was incredibly important in the case, and was incredibly important during the trial. And I was there for every day but one of the trial, where I had another client calling me across the country briefly, but I was right back. And the role that the civil rights groups played in advancing the testimony and putting on witnesses during the trial added a dimension to the case that I believe gave the court a deeper understanding of what the issues are in the real world, not just in a theoretical debating society about what college admissions is about or how it affects people, but to hear the tangible voices of students and how important many of the students at Harvard consider their background and the whole measure of their life story and their application, including their racial and ethnic identity, being a part of how they define themselves. And it animated something for the judge that I think the trial record would have been bereft without that testimony. And so in some ways, just as I was very pleased to be able to continue the defense of issues that I care greatly about, and approaches to admissions of which I have benefited and that have helped my life and my career advance. So I take these things personally as a beneficiary and also as a parent with college-age daughters. It's very important to me. But also there was a pride that I felt watching the young lawyers from these civil rights groups put on witnesses during the trial to fill out the record in a way that the university couldn't have by itself, because the university was speaking as an institution, very important and necessary. And we put on lots of witnesses that helped explain the processes and the approach. But that contribution of the civil rights groups was clear to me from the beginning, but it was clear to everybody by the end. And most importantly, it was clear to the judge, and you could see it. And it's worth noting that the only students that testified in the whole trial were those students, meaning there was no witness proffered on the plaintiff's side to advance the claim, as it were, of discrimination or the impact of the alleged discrimination. And the judge during the trial said, you have a no victim problem on your side, meaning that they weren't proffering the injury of which they spoke. They were sort of thinking of it as notional and not real and tangible. And the record that was established on the other side was more granular and well considered. And I think the over 100-page decision with almost 90 pages or so of factual findings bore that out. And so obviously you have to be focused on who your client is. When I'm flying the hat as Harvard's counsel, I'm no longer an NAACP LDF lawyer in that context. But I think that Harvard, my client, benefited from both my understanding of the value that the not-for-profits could bring to the litigation, and not insignificantly, the relationships that I have with the public interest and civil rights bar, so that we could talk to each other in ways that help coordinate strategy in a way that I think helps advance the case.
Thank you. And this is actually, you point out a very important thing here that I did not focus on initially, which is the Harvard case is also another different model, right, than what we just talked about. Because this is a model in which the private firm and civil rights organization are not co-counsel, but rather they are representing separate clients. In this case, Wilmer is actually representing Harvard as a private client, whereas the civil rights organizations are representing a group of individuals that clearly have a stake in the case that is perhaps largely aligned with Harvard, but not necessarily completely. And yet sort of they find that way to work together. So perhaps Niyati, if you could speak a little bit to that, to some of the dynamics related to these types of situations. And I should say that with respect to the Advancing Justice affiliation, this is a case that's also interesting because it was our Los Angeles affiliate that really brought this case forward in the first instance to sort of bring out and to have them have the students testify, the Asian American students testify in this particular case. And the other thing I would ask both Debo and Niyati is, don't be afraid to ask each other questions as well, or it really engage in this sort of conversation, because certainly this is a chance for all of us to learn. Certainly I'm learning along the way. So Niyati, if you could speak a little bit to that. Oh, and you're on mute right now.
As litigators, we don't ask other lawyers questions. It's bad form. We're supposed to pose the questions and answers to the court. But I will say, I want to echo what you said. Big shout out to our LA affiliate who really did a wonderful job at trial during the Harvard case. And we're so happy that we were as AAJC to be involved in the appeal process here. And shout out to LDF and Lawyers Committee and all our partners who've been involved in that. It's a demonstration of how this issue affects all of our communities, right? And that's one of the reasons why we leaned in. It's not, yes, in this particular case, the plaintiffs, SSFA, targeted and tried to use our communities as a wedge, and we certainly are not going to let that happen. But affirmative action and race-conscious policies are important to all communities of color because it gives us our individuality. It allows us to showcase our individuality, and that's why it's important that we were all collaborating together. And as I mentioned earlier, when we have these cases in areas that we focus on as a civil rights community, sometimes the direct impact is not on us as Asian Americans. Sometimes it's to our brothers and sisters in other communities, whether they're Latinos or Black Americans or any other particular community, whether it's the LGBTQ community, as the case might be. But it's important to be allies, because if it's them today, it's us tomorrow, and the other way around. And so those are really important considerations when we do our amicus work. And sometimes what seem like very dry technical cases also allows us to show the court the human impact that affect our communities, which we did in one of our briefs that involved broadband access, where it was, a utilities company and a a telecom company fighting it out, and one would think, what does that have to do with our communities? But broadband access, as we all know in these pandemic circumstances, is incredibly important, and access to broadband is really incredibly important. And as amicus, we were able to lean in and explain to the court why the seemingly dry issue really had resonance for all of us. And one thing I want to add also, not just in the Harvard affirmative action case, but to go back to the citizenship question challenge that we had, there were 6 cases, but of all of them that went to trial, ours was the only one that allowed the community voice in during trial. We had, representatives from a Latino organization and an Asian organization explain how the census matters to their communities that they serve, but more importantly, how they are instrumental in ensuring that the census is success. And in one of our plaintiffs from New York, John Park, who represents the MinCon Center, testified how they changed the undercount rates in their census tracts directly because of their involvement in partnership with the census, and why the voices of our communities are so essential and need to be uplifted, whether it's through advocacy or litigation.
Great, thank you. Let's talk a little bit about sort of resources. I mean, I think we've talked somewhat about sort of resource needs of nonprofits, how law firms can help there. What are some of the practical things that you guys would want to talk about, sort of when you talk about resources that a nonprofit needs? What do you look to from a law firm? I mean, it's additional staffing, right? But what are some of the other nitty-gritty things or is it a question of, let's even talk about basics like deposition transcripts or things like that. How does that work in terms of sharing in the costs, or do they share costs, or anything along those lines? And maybe let me ask Niyati first and go from there.
Well, for us, we are a nonprofit organizations. Our resources are never enough for all the work that we have to do. So when we have pro bono partners, that's really where we can really lean in. We're very good with getting creative about how to stretch our resources. But, I think that deposition transcripts, court reporters for depositions, for example, discovery management systems, all of these are incredibly costly, and we don't necessarily have in-house. We don't have things where we can bind briefs, for example, that are sometimes required by courts, and service of these things. These are all costs that really add up for us. And, we can have all the substantive expertise and the litigation expertise in the world in-house. And, certainly when it comes to substance, we certainly do. But these are the resources that we don't have that, sometimes impact our ability to bring a case. And if we can't find a pro bono partner, sometimes we're not allowed to.
Great, thank you. And I see that we have some questions coming in, so we will definitely get to those. Please do keep them coming in as well. Dabo, let me ask you, in terms of when you're working with nonprofit organizations, maybe I'm just going to ask you, sort of, what would be one piece of advice that you would give to the nonprofit organization as to how to make your life easier from the law firm perspective?
It's a great question. I guess having a clear understanding of what it is you're trying to do and why, talking about what the goal of the litigation is. Does it require some type of immediate temporary restraining order or preliminary injunction type of filing? Is it going to have a longer wind up and a longer window? Thinking about the strategy of the case. Very often, particularly in the context that we see right now, there is a sort of a race to the courthouse challenge to sort of meet the various incursions that are happening across the country. And that becomes very challenging because of necessity. You want to try and stop these things and get immediate relief, interim relief right away. And so it's a little bit harder to have the time to develop a case and to think about the strategy, but there still are times when you can be doing that and thinking about the case and strategy. And in those situations, I think it's good to have the public interest organization have done some work in that regard, but also to sort of bring the firm into the discussion, because the resources of the firm and the financial resources, many firms are very generous in that regard. They understand the circumstances of our public interest brothers and sisters, and they're willing to definitely support more than their share of these expenses in many circumstances. But they also like to be in consultation and in collaboration with the strategic pieces and with the learning opportunities to advance the case. And sometimes there's some strategic input that while the firm may not have the subject matter experts, they may know something about the courts. They may have associates that clerked for particular judges. And so you see that very often where you're sort of thinking about where is the venue, and there will be some knowledge within the firm. In a big firm that has 1,000 lawyers, there's a way to get on email and sort of ask for the institutional understanding about what we know about these courts or a particular type of relief. And very often you get resources coming back because there's so many cases happening in so many places over and over again. And so that's a way to leverage it up. And having a public interest organization drawing upon the intellectual capital as well as the economic might of the firm, I think is a good way to come at it. I will say that the inverse of that is that firm lawyers need to come into these relationships and have a degree of being humble, to not necessarily assume that although you might be an expert litigator, you might not know about a particular area of the law. You might not have the same exposure to the community. There are things that if you're in a client meeting or looking to talk to clients or trying to get institutional clients to sign on, Niyati spoke earlier about doing things in a culturally appropriate way and in a way that is consistent with the expectations of the client, whether it be an individual or an organization. And there's a lot of learning, I think, that can happen on the firm side also to see and observe, or sometimes participate in, what it's like to build a case up and what it's like to be in dialogue with your clients and bring them along. And I think you have to be humble to some large extent and be open to that, and not think that by virtue of being associated with some well-known firm that makes you an expert in everything. None of us are experts in everything. And if we're good lawyers, we're always willing to learn something about the next case and the next matter. And so having that degree of humility in the way that you approach litigation and in the way that you approach your co-counsel, and being open to learn from the partnership, I think is a very important ingredient in trust. And then when you have tough decisions to make, it creates a context for an environment that can lead to allowing the best ideas to percolate up, as opposed to arm wrestles over who is going to make the call, which is typically not the most constructive way.
Great, thank you. Along those same lines, here's a question that was posed by the audience, which is, have there been occasions where the collaboration between public sector and private sector has not worked out? And what are the root causes, if you will, that might cause that to happen? It looks like Niyati, you want to chime in on this.
I want to say more that it behooves both parties to do their due diligence, right? I think you reduce chances of it not working out when you know who you're getting involved with and what the issues are. And I think Debo talked about this, right? Share what your goals are, what you want to do with your partners, so that you make sure that you start out on the same page. Some organizations have also given out their value statements about, like, this is how we do things, what our goals are. And I think those are great things. But at the end of the day, I think having a clear understanding of what you want to do and achieve, and what interests you represent is the starting point. And that usually helps avoid any negativity or conflict.
And I would just add on that point that sometimes where you have firms or co-counsel that are not willing to respect some of the different competencies that Niyati and I have been speaking of, and to want to push into areas where perhaps the firm or the firm associate should be playing a secondary role if you have an associate that's too eager to demonstrate their competence and has a vision of what the case represents to their career development more than they have a vision for trying to do some good in service of their client as a collaborator, sometimes you can have situations where you find that you're trying to rein in your firm co-counsel and trying to to get them to play a role that is more constructive to the overall goal. I have seen that happen in some contexts. Sometimes you have situations where the law firm has a bunch of junior people but not enough supervisory structure, and so then it becomes a little bit of a challenge where you have the more senior lawyers and the public interest side having to in effect supervise the lawyers on the firm side without an adequate structure in place. That's one challenge. And sometimes you have firms wanting to push into spaces where it's best to hang back and let others lead. Now, one structural thing that I want to suggest can happen is that there's often a co-counsel agreement, and the co-counsel agreement can anticipate how you're going to address certain key strategic decisions. And so you can have a going in understanding, a meeting of the minds, a contract of sorts about how you're going to do that. It's particularly important because sometimes you have multiple parties, you have multiple entities, multiple sets of lawyers that are all in it. And so you have to figure out, well, if there's a disagreement in terms of a strategy call, then what happens, right? And it's important to do a little bit of thinking on that because there are valid considerations on both sides. For example, I take it that a firm would not want to give away a strategy call if the consequence of the strategy call was going to be to dramatically expand the cost of the litigation without the firm having some say about how it was going to manage resources and what it was going to do. It would be important for the firm to have a seat at the table to get to the right place, but to do it in a way that was considering the costs at issue, and that although it may not be the public interest organization's money, it's somebody's money, and you want to do it in a way that's going to advance the litigation and that isn't wasteful. So there are different ways in which this can be structured. You can never take all of the risk because you're dealing with human beings. So you can never take all of the risk out of the equation. But if you come into these things with good faith and you are vocal up front about what the expectations are, in most situations, you can resolve these things up front. And not in every case, but in many cases they work out. There are some cases where sometimes I think you have public interest organizations saying that they're never going to work with a particular set of lawyers again, or maybe even a particular firm again if the relationship isn't good. And maybe it happens in the other direction as well. But I think in most situations, it's the rare case. And as I said, I've been on both sides of this. It doesn't often happen that it breaks down in that way, but it's possible.
Great, thank you. Another question came up in terms of multiple lawsuits. I mean, I think we've seen in a number of these higher profile cases, whether it's census, whether it's immigration, whether it is presidential subpoenas, that there are multiple lawsuits being filed. And a question that certainly I've gotten is, well, why are there so many of these? Is that actually efficient, especially considering nonprofits, all of us are so strapped in terms of resources? So can I ask you guys to speak to that? Maybe start with Niyati.
Well, I will say that for us, we sometimes join in these situations because it's rare that anybody's representing the interests of the Asian American community. And we're small but mighty. But it matters. Our experiences matter, and it's important to remember that we're not a monolith as a community. And as an organization, we're very mindful of that and to represent the diversity of this greater umbrella that we call the Asian American community. So that's definitely one reason why you would do that. And I also think, that there is some value to have multiple courts say that this is wrong, as that happened in the citizenship question case, where 3 judges in 6 different cases all said that this was pretextual, that Secretary Ross hadn't really given the real reason for why adding the citizenship question. And then it went further in our case, which was really helpful I think, in altering what the administration was going to do ultimately, because we had a live equal protection claim that wasn't before the Supreme Court. And when the Hoffler documents came out, that claim, suddenly was, even for our judge who had ruled against a trial, was reopened, basically, because the appeal hadn't finished in that. And so there was going to be more discovery on who knew what, when, and how about these Hoffler documents, and how that played into their ultimate decision to add the citizenship question. And I think that that had a significant impact on whatever decision-making processes the administration was engaging in behind the scenes. So I think that this is, I think one of those places where having multiple lawsuits, and I want to give a big shout out to Malda for, really just pushing on that equal protection claim, because it really paid off at the end. I think that having multiple lawsuits has different benefits, and sometimes it creates, or if you have a bad draw, it allows you to create good law somewhere else. And I think that's important, as we as lawyers really do know that that can sometimes matter.
Okay, thank you. And just for the people on this that don't necessarily know what the Hoffler documents are, that's a reference to, you've probably seen it in the news, there was a deceased Republican operative that wrote a memo on how having a citizenship question would depress the political power of non-white Hispanics. I believe that was almost verbatim the words in his memo, which obviously goes to Niyati's point about making an equal protection claim just a little bit stronger in that context. Davo, do you have anything to add to this?
Yes, and I guess I would put out there the other side of the challenge of having so many cases, which is that you can have bad rulings also, and you can have split decisions, you can have circuit splits, which may queue them up in a particular way for appellate review or Supreme Court review. And so there are some benefits. I mean, another reason that sometimes people do this is because the cases that are brought may not be so broad as to seek nationwide relief. And so if you're bringing a case, there could be a victory in one part of the country, but the victory doesn't extend to people or students in your state, for example, or in your circuit. And so there's, sometimes there's a need to bring a case to make sure, or to try and make sure, that you have the protection of any injunction that's issued. So there are a number of reasons why you see that, but there is also the risk that there could be decisions going in different ways that queue up the case for appellate review in a way, and lead to inconsistent judgments. So, it's tough. Everybody has to measure what is best. There's a pressure, and I know this from the not-for-profit side also. Like, when there are issues that are touching your community, there's a pressure to make sure that your voice is being heard and that you're being counted in these cases. Let me take it out for a second of the not-for-profits and the big law firms and just talk about the educational institutions. Recently, there was a case about whether or not students were going to be able to get visas. International students were being able to get visas, and there were a bunch of cases being filed all over the place. And my colleagues at WilmerHale brought a case on behalf of Harvard and MIT in the District of Massachusetts, which coincidentally wound up back before the judge that tried the Harvard case. And ultimately, the United States relented on sort of moments before an important hearing before the judge, and sort of stepped back from the policy as it had been announced in substantial measure. But there were a lot of calls across the country, like, different schools wanted to be in the case. There were a huge number of amicus briefs of collections of colleges and universities and others, because everybody wants to be counted and wants to be seen to their community to be doing what they can to resist the impact of these very harmful policies on a segment of their community. And so sometimes there is just a real world political pressure, if you will, to make sure that your voices are being counted and are of record in a meaningful way. And that's a challenge that's real also, but it's a challenge that sometimes mitigates against having the most strategic case in the most strategic place with agreement and everybody sort of focusing on that case as the vehicle. It's a countervailing concern, but it's the real world in which we live. And so, that's one of the other parts of having the propagation of so many civil rights entities and voices. In the old days, it used to be LDF and MALDEF, and there weren't. Obviously there were lawyers across the country that brought cases outside of the mainline organizations, but there were fewer. There weren't as many. Now there's a more of a propagation, and so everybody's feeling those pressures to sort of be out there and be advancing their mission in meaningful ways.
Great, thank you. We have a two-part question that's not quite related, but I think would be useful for you guys to answer. The first question is, how can you fuse morals and ethics systematically with the law? And the question says, the law is bendable to human needs, but these judgments are subjective at core. And so the question is sort of, as you guys think about the legal system, especially since you do social impact litigation, is sort of how do you put the two together in terms of morals and ethics and the legal system as a whole? The small question, as the listener herself put it, and this is clearly coming from someone that is either interested in law school, or considering an area in law, is how much does math matter in becoming a lawyer? So I will let you guys decide who wants to go first and how.
Maybe I'll start with this one, and I'll root around in the dark, and then Niyati can introduce a corrective as I fumble for something coherent to say. So, in many of the cases, particularly the cases that not-for-profits are dealing in public interest organizations, there is an underlying sort of moral current running through the cases, whether it's about being recognized or not marginalized, or being treated with equal dignity before the law or before the institutions of the country. And I find that when we're trained as lawyers, we're trained in the precedent system, we're trained to do statutory interpretation. But in some ways, one of the things that I think you learn to do as a public interest lawyer is to not allow the procedure and the precedents to totally submerge and erase the underlying human value or the call to morality that is part of the impetus for your cause, and to frame the case in a way that sort of gets to the core issue and the gravity and the importance of it. And sometimes we do it within the umbrella of a constitutional principle or a statute that was designed to recognize the full inclusion of various segments of our society, often that came to exist only because of the moral sacrifice. It's important to sort of think about the through line between what John Lewis and the marchers on the Edmund Pettus Bridge did to demonstrate by putting their bodies on the line that the country was not living up to its promises, and literally showing at risk of their lives and their physical well-being that the country was falling dramatically short of its promise, and to essentially demand through personal sacrifice, in some cases human sacrifice, as the case would be for the likes of Jimmy Lee Jackson, Viola Liuzzo, Reverend James Reeb, Goodwin Chaney, and Schwerner, that there was an imperative, there was a commitment, there was a democratic value to democracy writ large that was not being met, and that it was not okay to turn a blind eye to it anymore, and that the country needed to grapple with it. So that organized mass movement literally put the question to the country about whether it was going to continue to fall short from its constitution. The 15th Amendment was there. All of what you were seeing was in dereliction of the amendments that came after a civil war was fought, and you still had 100 years of violations after that. And so whenever I would argue a case about the Voting Rights Act, it was never too far from my mind that this was a statute that was about voting and democracy in the political process, but it was a statute that was for the first time in the area of voting successfully, because there had been other attempts that didn't get there, but successfully made a national commitment to a minority inclusion principle in our democracy. It sort of forced the question and said, we're going to do now what we said we were going to do in the Reconstruction era, but haven't been doing. And so when you argue those cases, when you're trying to articulate those cases, I think not losing that through line in the way that you formulate your arguments is very important. And I think it's something that an effective advocate will do. Now, you can do that and lose. I know some people on this video that have done so in dramatic fashion, and it's not Niyati. So, so there are times when you fall short of your objective. But the core point is that you don't have a guaranteed result, but you can guarantee that a truth and that the needs and that the imperatives of your clients are being given voice, and that you are, in a sense, a voice for the voiceless and those who have sacrificed for the statutory regime or the constitutional principle to be there. And so it's not always the case that you have the morality and the law like walking in lockstep, but I think there is a unique opportunity for public interest lawyers to try and find the common path for those two things and to be engaged in a knitting process of putting those things together. And in so doing, what you're actually doing is you're knitting the undercarriage of the democracy together by doing so. So that's how I think about it in some sense.
I want to just say first thing, Davo, I sat in during the oral arguments at Shelby, and there was nothing that you did that resulted in that. I mean, I think we couldn't have asked for a better advocate. So thank you for all of us on that. And so again, to go back to this, I mean, it is, as Davo pointed out, sometimes a little bit easier when we're working for a civil rights organization to know the moral compass and to be responsive to our communities and their interests and to look at the larger picture, because that's what we've signed up for. But where it gets hard is going back to keeping in mind the strategy. On the one hand, we have to advance things and set the precedents themselves for these things, as our civil rights leaders did, as Thurgood Marshall did in the civil rights movement, as John Lewis did. They actually hoed the road for all of us that we're following today. But as we continue that work, we also have to be mindful of all the people that are coming after us in the civil rights movement. And one thing that I'm always conscious of it, and perhaps sometimes too much, is to say that, you know, if I pursued this strategy, what would the consequences be for all the cases that are going to come after me? And am I going to make it harder for them? Sometimes you don't have a choice, because you just have to stand up for what's right and what's moral, and create good trouble, right? And that's what we have to do as civil rights lawyers. But so the math comes in there. Sometimes you have to take the smaller victory and not go for the whole enchilada, because it's not the right time for that second step yet. And I think those are the hard questions that we face as civil rights lawyers all the time. We know what the end goal is, but we kind of have to go there incrementally to get there. And if we overreach, we'll set ourselves back. And that is some of the calculations that go back. So I think that's also another important consideration.
And building on that point, I would just say that just coming back to the math point, you know, that in lots of these cases, there are experts and statisticians. For example, some of the star witnesses in the Harvard case were the economists, the folks that were doing the regression analyses and trying to isolate the variables and doing the statistical analyses to show whether or not various factors were impacting the chances of admission. If so, how much? And we're really dealing with sort of advanced models to try and determine and assess and isolate the process to sort of identify if there was discrimination or wasn't discrimination. In a voting case, very often these cases under the Voting Rights Act, they turn on the degree of racially polarized voting. If it's a redistricting case, for example, and you're litigating a certain type of redistricting case, and there will be these regression models about what is the extent of racially polarized voting, how significant is it, what is the point of opportunity in the district, where the district is diverse enough such that it creates an opportunity for a minority candidate to have an opportunity to be elected based on the composition of the district, based on assessments of voting patterns and historical records to see. And you can see that it may vary widely, even within a state. In certain places, a district of a certain balance may create an opportunity for a minority candidate to be elected. And in another place, every minority candidate you may see is defeated because the polarized voting is so intense. And there are statisticians and experts that are digging in. That's just a couple of examples. Certainly if you're in employment litigation, there's a lot of statistical analysis, pay equity issues and other things. So I think that it's almost limitless to think about how somebody with a math brain can advance litigation causes and think about it. Right now we're talking a lot in civil rights about engineering and algorithms and the science behind machine learning, and how we're building these complicated systems to drive businesses, but perhaps affect various lines of business. And so I think that a math brain in specific and in general ways, because you think about things in very precise ways and want to sort of isolate and get to the right answer, can be trained to really add value in a legal context. The only caveat I will say is that very often in math, there is a right answer. You can get to the right answer in some way. And sometimes the law is more art than science in that sense.
Great. Thank you both for that. And let me add, because actually I do have a math background. I actually agree and disagree with you, Davo, in the sense that it was interesting because by the time you get to upper level math courses, you're almost writing essays rather than formulas with an answer. So even the math is malleable. But yeah, I think both of your points is also important, is that math is important, but also that you guys as litigators, part of your job is to be able to explain the math in ways that are understandable to a jury, understandable to a judge. So that's very much appreciated. The last question we have, and I'll be honest, I'm not sure exactly sort of where we're framed in this, is have any of you come in contact with student debt issues? And I might broaden that also just in terms of the civil rights context, but also perhaps in your own careers, right? How much should young lawyers, law students think about debt in terms of choosing career paths?
Should I start, or do you want to start, Niyati?
I can do it a little bit, then Debo, you can give inspiration.
You first this time, you first.
Well, I think, student debt and debt in this country and, economic justice in general are really important. And I think they're civil rights issues. So I think that, it's not something that we necessarily have leaned into here at AAJC, but they're incredibly important. And they shape so many of future decisions for so many Americans these days, because it affects what their career choices might be or not be. As law students, I think that we come into debt. Going into the private sector is very attractive at that point. I would say, yes, that's important, do it, but please come back to this side as soon as you can. It's really important, we need you. And while you're on the other side, support us. So I would say those two things are important, but I think that as a matter of economic justice, I think it is a civil right, and especially in this day and age, and it should be at the forefront of all that we do.
Yes, I think these issues are vital. I mean, I guess I encountered them first as a student, and I just remember how emotionally draining it was to have to fill out the FAFSA form when I was going to college. I came from a family of very modest means, and it wasn't complicated math to fill it out, but it was sort of a very tangible reminder of the absence of resources that was a regular part of my process in making sure that I qualified for my loans, for my Pell Grants, and the other subsidized and perhaps some unsubsidized loans. And so it was a very tangible and real piece of my personal educational aspiration. I then, part of my choice, I think, to begin to Niyati's point, part of my choice to begin my career in a law firm was in part to try and manage the debt that I emerged from college and law school with, which seemed like a lot of money many years ago when I came out of law school, but now would be considered relatively modest in relation to the fantastic burdens that so many students have when they come out of school. I think we have to understand that what we're doing is that we are essentially forcing many of our young people to come out of school and enter the workforce already with mortgages on their brain, in effect. They already are carrying this weight that you would think you would want to put toward a house or something that appreciates, and yet you've had to invest in the cultivation of your own future and opportunity at a staggering level, sometimes at levels that sound a lot like a mortgage in a lot of places. And that can constrict choice early on. But very often there is a way to manage it over time. And for some people, there's a way to sort of break through. And, I was fortunate to be able to have a job that allowed me to pay it down. And I realized that not everybody has that good fortune. And so it's not a path that I'm suggesting is there for everybody. And I'm not suggesting that by itself is the answer. There needs to be some type of thinking done about how we address these issues more broadly, because they can't forever just keep going up and make educational opportunity out of reach of folks and huge swaths of our community. I don't think that that's sustainable and will keep us competitive. But when I left the big firm to go join LDF, I took a 2/3 pay cut to do it. But it was, perhaps the best career choice that I ever made in my life. And there's no amount of money that could cause me to revisit that choice that I made. And there's no amount of money that could have made up the difference of the experience I had doing this work and trying to advance this work and to learn the things about my country that I was able to learn of being up close and personal to what some of the structural impediments are, and how important it is for those of us who have had the opportunity to go to school and to get these degrees to use some measure of our time and talent in service of trying to open doors for others. And so it's not a perfect answer. It's a very serious issue that this question points to. There need to be more structural responses, but these are very tangible issues that affect people's lives and that I've had occasion to think about both as a student and now in a different way as a parent. I was so traumatized by the FAFSA, I didn't even want to fill it out for my own daughters. And unfortunately, my wife took on that responsibility for us because I was still dealing with my post-traumatic stress.
Great, thank you both. As a final question, and I'll ask you to sort of keep it brief if you can, is for the listeners, the people that have watched this, if they are inspired by sort of what they've heard from both of you, what would be one action item that you would ask them to take? Recognizing that we do have many lawyers and law students, but not all the people on this call or on this webinar are lawyers and law students. So perhaps let me start with Niyati on that.
Well, get involved. Whether it's if you're in a law firm, get involved with pro bono work. Get involved with your community organizations. Do what you can to contribute. Stay the course. That's really important. It's incremental and sometimes it's very frustrating, but it's helpful. The other thing I would say, please register to vote, help a friend register to vote, and then cast a ballot. And along those lines, please complete the census, help somebody else complete the census, make sure they've done it. These are really small steps that you can take even in a pandemic. And that, helps us all represent our communities better and give voice to so many members in our communities that don't have one. So if we do those things, I think those are really important action items that we can take immediately, and find a way to get involved with AAJC. We would love to see you.
Those are very good answers. I would join those answers and perhaps make a more specific version of the vote piece. Everybody who's listening should not only vote themselves, but they should find 2 people who aren't registered to vote, encourage those 2 people through their own advocacy to register to vote and to cast their votes in the way that Niyati has suggested, so that we can expand the democracy, but make the commitment not just to do it in this coming election, but make the commitment to do it in the following election as well. Very often people are focused only on the presidential elections, and they're not focused on making voting a type of civic engagement that is recurring. And there are important decisions being made in the spaces and in the local elections that are as important as some of the big elections. And so I would just say that carry that through in a very tangible and specific way. One random one is to buy the book Devil in the Grove. If you haven't or read it yet, Gilbert King won the Pulitzer Prize in 2014, I think, for nonfiction for his book Devil in the Grove. It's a book about a criminal justice case in Florida at the time of the Brown v. Board cases. But the reason I think that book is so important is that it's telling a story about America in that time, that when you read it will help you understand some of the issues that we're grappling with today in this time. And there's a through line between that book and the stories it tells and some of what we have seen recently. And it will jump out to you. And it's also a beautifully written book by a gifted author. And then the last thing I would say is everybody should think about some civil rights or freedom movement cause that they don't know something about and might not be within their own personal experience, and try and learn something about that cause and what the effects are on that community. Pick something that seems like it might not be the natural thing, but you can learn from each and every one of these causes, and the amount of cross currents that flow through these things might surprise you. And so I think too often we're sort of thinking about things in the narrow way about what immediately affects us. But part of what you learn when you're in this type of work over a period of time is that there are things that affect all of us, and that we have to be prepared to answer and live our values for all of us. And one way to do that is to walk a mile in somebody else's shoes, in the way that John Lewis and the folks on the Edmund Pettus Bridge tried to invite America in to see what it was like to be African American in the southern United States in 1965. So those are my suggestions, and they weren't brief, so I apologize.
Thank you both very, very much. So we've heard some very useful advice. Vote, get your friends to vote, do the census, get your friends to respond to the census, take a look at places that you might not otherwise have thought of with respect to whether it's civil rights, social justice, and looking in different places, reading a book like Devil in the Grove to understand some of the history and context. I think these are all very useful suggestions. Let me add one more, which is donate to your causes that you believe in. Certainly, if you are inspired by what you heard tonight, we would ask you to donate to our litigation campaign. You have the link in the chat box, and we would encourage you to do that, because it is through the support of people like all of you that we are able to do the work that all of us try to do to defend our communities, to advance our communities. And it's a critical part. As you all know, it's a critical time right now for all of us to be involved in all of these different ways. And even if it's not our organization, certainly if there are other causes that you believe in, to Debo's point, even if it's not specifically in the racial justice realm, we urge you to get involved, because if all of us are involved, it does make for a better democracy. So thank you all very, very much. Thank you again to our speakers for your inspiring, thoughtful, insightful remarks. And thank you all for listening. Be well, stay healthy, stay safe. Thank you.